You got an egomaniac sitting in this chair.
Yes.
Beware.
I hope you just let it all out.
Foaming at the mouth.
Yeah.
Like the Hammer Shapiro.
Mouthful of swear.
Lew Heisman finally snapped.
Yeah.
After all these years.
It's always,
No one said it could be done.
always been a thinly veiled facade, ladies and gentlemen.
Welcome to 6-Minute Increments, where we talk about and deal with legal topics as they relate also to business. But today we have a special guest, Lew Heisman, a fellow lawyer. So this is triple billing here.
Yes.
Each minute that goes by is probably the most expensive minute any viewer has ever seen. Lew, welcome.
Thank you.
Why don't you tell us a little bit about yourself and your legal practice?
Sure. I'm a divorce lawyer. I practice in the matrimonial field. I've been practicing in this respect for 45 years or so. I'm a partner at Heisman, Nunes, and Hull, and I'm happy to be sitting with Brett and Beth this morning. I have a mouthful of information regarding my divorce practice, and happy to give a narrative or to respond to questions as you wish.
I have so many questions.
I bet you we all do.
Yes.
That's why you're a hot topic for being here. A little bit more about your background, Lew. Like, how did you get into this field? How'd you get into practicing law?
Okay, out of law school, I became an editor at Lawyers Co-op Publishing Company. I was there for 6 years looking to practice privately and dabbled in it. There came a time that Chamberlain DeMonda law firm offered me an associate's position, and I, in quick fashion, became involved in divorce law, and in quicker fashion,
Is that because no one
practiced.
else wanted to do it?
I don't know that.
Yeah.
I don't know that. Perhaps that could have
Or
been
you had a
the case.
passion for the area?
There was a partner there, Anita Miller, long past now, who was very active, significant caseload. She needed help. I began to help her. Things worked out. Began to go to the courthouse, and the courthouse became my home away from home as I worked downtown for all those many years. From that point, I went to Underberg Kessler Law Firm, worked there for 20 years, having been a partner at Chamberlain DeMonda and a partner at Underberg. And then I, along with Paul Nunes and Ron Hull, decided in our twilight years of practice that we'd open our own shop, and here we are.
Why'd you ever go to be a lawyer?
Graduating from college, I knew that there would be more schooling for me, which was to avoid the workplace.
Fair enough.
And I was attracted to law school, not necessarily to divorce law, but that's simply the way it happened. And here I am, and I've been typecast, if you will, for all these years.
I mean,
with
you followed
movie
that.
screens and movie scripts in my head from all my work.
I know you refer to it sometimes as soap opera law.
I do.
How do you, you're dealing with people going through some of the worst moments in their personal lives.
Yes.
And so I'm sure they're not at their best. How do you deal with that?
I deal with that for starters in my initial consultation, which is to listen. They want to spout out all that's been going on, some of which is helpful to me, some of which is just to allow them an opportunity to talk. And then what I do is as I refer to it, 3 quick credit hours of Divorce 101. So they have a framework. And I tell my new clients that I can give them a range of outcome, but I cannot promise them what the resolution of each issue will be. And we'll discuss and we'll negotiate and hopefully come to settlement.
Now, we work off of 6-minute increments. Do you also bill on a different hourly rate or flat rate, or what's your billing
I bill at an hourly rate.
Hourly rate?
To the 10th of the hour. Yes.
To the 10th.
Yes. And in particular, these days, my hourly rate is $450. And like all other divorce lawyers who walk the earth, we, as required, sign a retainer agreement with our clients and bill every 30 days, the requirement being 60 days, actually, but we bill every 30 days and bill against that retainer.
I would imagine that a lot of your clients are not what one would call a sophisticated legal services user. They don't deal with lawyers all the time.
Yes.
So they're probably shocked when they get those first bills rolling in.
Yes, and that's why it's important to tell them up front and not to push that aside. Legal bills in the divorce world are expensive. Hours mount up quickly, especially at the start. So you cannot avoid that conversation. You have to look your client in the eye and tell him or her what's to be expected. So they do have an idea, yes.
Do you get a sizable retainer up front
Yeah,
typically?
yes, I do. And so these days, if it has some complexity, that is the prospective case regarding financial issues, and there are young children with whom to deal, the retainer is $15,000. And I will tell you now, and as I explained to my client, that is not a capped fee, and I have to emphasize that so they don't leave the office thinking, well, the maximum is $15,000. It is time-based. If the matter is concluded with time less than $15,000 expended, I refund the balance. It's not mine. I'm holding that money in trust. If the matter requires greater time for a total beyond $15,000, that ultimately will be the bill.
I'm glad you're not shy about telling numbers, because I think that's very helpful for people to hear.
Yes. Yes.
Do you find that most lawyers that you've been a practicing lawyer, you've been a partner at multiple locations, you've had a lot of experience with other young lawyers. How do you approach or tell a young lawyer where you're at in terms of discussing the money? I would say my experience is most lawyers hate discussing the money.
Yeah, and my quick refrain and response to that is, this is not my hobby.
Right.
I don't work for free. This is very tough stuff. And as Beth said from the start, I'm dealing with people who have likely the most traumatic event smacking them between the eyes. Mm-hmm. And so there's a financial component to all that, and it's unfair to the client to refrain from expressing that. You have to tell them up front. You have to let them know. And a response to that may be, and certainly is on occasion, that clients will choose not to retain me because I'm at the higher end, given the fact that I've practiced all these years, I have expertise, and it has just come to that amount of hourly rate and retainer. Yes.
Do you find that for most of your clients, you're the first lawyer that they've ever actually had to engage or work with?
In many cases, yes. That's right.
And I guess that goes back to them not being as educated or sophisticated. I mean, do you ever have to just train them how to call you? I mean, I know that Christian Valentino, another litigation attorney, he'll have to talk to them as you're sitting on the phone. You got to remember the timer's running.
Yes.
I'm billing you for that.
Yes. And to those clients who just want to hear from you with nothing of any significant consequence daily by email, it's time devoted to the file. And it would come to the point where, hey, if you continue to have contact with me and there's really nothing in the way of substance I can advise you, then you might want to hold off a little bit and wait for another few days to see what's going on. Or on the other hand, I will just tell them that, I'm not going to bill you. Or in fact, I indicate on my bills, no charge telephone call with client regarding status, that type of thing. And if I might say, I do believe that clients very much appreciate a billing entry, which is no charge with an explanation why, because they're paying a lot of money.
Right.
Right.
And they deserve a break if a break is appropriate.
Now, how often do you experience that clients are reaching out for that, especially in what you're doing, that kind of daily touch?
Often, and it's a constant in divorce law to have contact with your client. And it's a constant in divorce law for a client complaint that I have not heard from my lawyer. I don't know what's going on. That's inexcusable. The easiest thing you can do is to respond in timely fashion to your client. And the clients will very much appreciate that. They have to know what's going on. You can't keep them in the dark. It's not fair. That's not why they're paying you.
Now, how long do you find that these matters typically take?
Too long. And all the hokey sayings that come out of Lew Heisman's mouth, one of which is, the wheels of justice grind slowly while the calendar races. And I tell people, just yesterday was Christmas. Tomorrow is Easter. The next day is 4th of July. But where is our case? So leaving it to the courthouse, things will go slowly. If we can push between attorneys and progress the matter towards settlement, that's the better way of going. But nonetheless, my answer has to be takes too long. And so to quantify that, it's nothing for a divorce action to take a year and a half.
Now, do you find that there's a lot of people locally who kind of dabble in doing divorce law, or is it kind of a core group of people? And is it regional, or how far out does that region typically go?
Yeah, well, the region here would be Western Central New York, Southern Tier. Yes, there are people who dabble in divorce because there's a lot of divorce work. And some clients, as you have suggested, are uninitiated, and they may be looking for a bargain price compared to those handful of us who have done this for a very long time and charge at the higher end of hourly fees. So yes, there is that. And to that end, it's fairly common that divorce clients will change attorneys through dissatisfaction and through, as
You
we
take
mentioned,
those matters.
I have in many, many cases been
Yeah.
the second or third attorney in. It's very tough to jump in the middle, but that's what happens. And yes, I do that.
Now,
Yeah.
what thing complicates them the most? I mean, I can imagine dealing with real property when there's a business owner, kids.
Yes.
What kinds of things, I guess, cause the greatest problem or most of the negotiation back and forth between the parties?
Okay, so we're going to get right into the
Can I
heart of the
guess?
substance.
I want to guess kids.
Kids, of course, and that's right at the top of the list when you meet a prospective client. Do you have children under the age of 21? If you have children under the age of 21, there are three matters to deal with, and they are custody, which to an attorney means decision making. It doesn't mean time spent by one parent as opposed to the other parent. It means decision making. Decision making has to do with what I refer to as the big four, Brett and Beth. The big four are health, education, religious upbringing, and activity participation. And if there's going to be joint decision making and there's a major concern, one party cannot unilaterally call the shot. There must be discussion. There must be contact with the expert, doctor, teacher, coach, clergy person regarding a major concern. And then there would be residency, the schedule of how much time the child will spend with each parent, and ultimately there will be child support. So yes, children will be one to one.
How do you enforce it after the fact? I mean, now that divorce has been finalized, but
Yes.
you're talking about now raising the child, which goes on for years after possibly you've
You have a
gotten
lot
a
of those,
divorce.
don't you? Where
Yes.
the divorce is complete,
Yes.
but there's a breach of the agreement that's been.
Yes, yes. Thank you for that softball. We're talking about post-divorce actions, whether it's an enforcement proceeding or modification proceeding. And if the divorce happens when the kids are in elementary school or toddlers, the likelihood is that there'll be some change along the way. You keep your fingers and toes crossed that the parties will be able to work those things to resolution between themselves because they have their cherished children and most important in their lives. But if it comes to a legal proceeding, then you see whether there has been a change of circumstance, whether there's been a justification for that change of circumstance, and then what is then or now the status of the parties regarding their finances, remarriage, and the like as to dealing with the kids. Residency schedule changes, child support increase or decrease, that type of thing.
And what
Yes.
triggers those types of things? The child support increase, the decrease? I mean, do they have to go
of
back to
income.
court?
Yeah.
What's the process that somebody would actually go through?
These days, child support modification is statutory. And there's three possibilities. Number one would be 3 years from the date of the most recent court order. Has there been a change? And if there has been a change, number two would be 15% increase or decrease in either party's income. So you can bring a modification proceeding 3 years following the order if you believe there's been an increase or decrease 15%. And then the last one, unfortunately, is usually the horror show, which is a unforeseen substantial change in circumstances. That's usually bad news, loss of job beyond your control, company shutdown, disability, that type of thing. So that's the framework with which we deal with child support post-divorce.
And if you've been engaged up front, are you kind of the person that most of them will come back to years later?
Yes.
So
Yeah.
you've got clients that, do you re-engage them or do you just kind of keep your engagement letter open?
Well, again, thank you. You presupposing the formality, absolutely re-engage.
Got it.
The initial engagement is limited to the divorce action. Once the divorce action is concluded by issuance of the judgment of divorce, your representation is done. Anything thereafter would be a new engagement, yes.
Do you have any tips? I mean, it's a strange thing to say, but do you have any tips for clients if
Yes,
they're
in fact, I do. The best client is a client who's a good record keeper. And I'm sure you find that in your respective practices, of course. So the client who
I am the record keeper usually. So.
the client who comes in with records without gaps as to income, debt, investments, those are the best clients, and you can readily prepare your work, because in a divorce action, a requirement is to fill out the pain in the neck 17-page statement of net worth form by each party respectively, exchanging those, filing those with the court system so that there is full and open disclosure of financial circumstances. That's the baseline from which we step forward to try to negotiate settlement. Yeah, that's the best client. And I also will say, now that you've given me the opening, people who are about to be married, who have previously been married, who have significant income or assets, who have a business, should execute a prenuptial agreement.
Ding, ding, ding. Listeners.
That's the tip. That's what's best. That's prudent. It's a prudent financial measure. And you're doing yourself a disservice otherwise, because...
How do you broach that topic? Any tips for somebody who's
that's a good question, because I typically do not have the opportunity to broach that topic. Most often it comes in because a business partner will say, "Hey, you're getting married. You better protect your interests, and I don't want to be the bologna in that sandwich as your partner."
Right.
Or a parent will say, "There's a trust. There's an expected inheritance. It's yours. I know that your glassed over eyes now is that love till the end of the earth, but it could happen. Separation or divorce. Protect
one would
yourself."
hope if you're going into a second marriage, you have a little more realism.
Yes.
And have been through
sometimes
something you don't want to have to repeat going through again.
Yeah.
And so you'll consider that.
Yeah. And so, if I may, a little bit more substance. In a divorce action, the law presumes that everything of value in the husband's name or the wife's name is marital property. That's a term of art, or marital asset. Boats, planes, trains, automobiles, vacation homes, retirement homes, timeshares, cash value, life insurance, travel points, anything upon which a CPA or economist could put a value in the marital pot, stirred up, divided between the parties. New York State's not an automatic 50-50 state, but a long-term marriage, more than 8 to 10 years, will result in a 50-50 division. The exception to the rule is the most important, and that's separate property. That's a term of art which comes in 4 possibilities. So if you don't have a prenup, you have the extent of this protection, but a prenup will carry it much further. The separate property can be premarital property. You come into the marriage with $50,000 in your sock drawer. Gift received by you individually, inheritance received by you individually during the marriage, or a personal injury award or recovery. The point is that if you receive any of these items, you must maintain it in your name. If you commingle it with your spouse, you're in trouble. You haven't protected your separate property. The prenup will allow you to do that, because the prenup can go on to say, rolling the clock back to the very old days when title controlled in divorce actions, anything in your name is yours. Anything in his or her name is his or hers, not mine. And if you acquire something jointly, you do so expressly with forethought, because now you have created a marital asset. So that's the beauty of a prenup. Very important.
Do postnups ever come up, or are they a rarity?
No, that's a very good question. The statute allows for a prenup, a postnup or marital agreement, a separation agreement, of course, and a divorce settlement agreement. So yes, it is odd. It's odd to have a marital agreement, but I've had them as recently as the last 6 months. Clients who just decided, things are not going so well. We still love each other, who knows what, but nonetheless, we mutually have determined that we should protect our respective and mutual interests. So let's enter into a marital agreement. And in fact, this happened, and I suppose the actual reason was business sale. One of the spouses owned a business, intended to sell the business. That was a significant enough event to say, time out. What do you think about a marital agreement? Both parties then going to their financial advisor. Financial advisor blessed the move, and marital agreement.
I mean, how often too after people forget to deal with their estate planning? I mean, I actually know some people who they got a divorce and then they went 20 years later and they forgot to change their will, so it still left things to their now divorced spouse.
Another practical concern, Brett. Yes, hand in hand, estate planning with divorce settlement.
Yep.
I can't do the estate planning.
Right.
The divorce settlement agreement is not going to be so comprehensive as to include all estate planning, but there will be provisions pertaining to estate planning that parallel the estate planning. And then aside from that formality, you grab the client by the lapels and say, it's time to do your estate planning or adjust your estate planning because look at what just happened financially. So yes, that should go hand in hand.
I've gotten involved over the years because they are a business owner. Now you've had a marital split and you've got shares of a company, or how are you dealing with that? The company itself might try to pull them back under the terms of the operating agreement. So sometimes it gets kicked back over to corporate side.
Right.
I guess my last question to you would be, any tips for lawyers that are thinking about getting into this space?
And I have a follow-up question to that. There's a number of fields, I would say at least regionally, where there's a lot of lawyers maybe in the back nine of their career, but there's not young lawyers really. So there's this gap. Are younger lawyers getting into divorce, or
that's classic?
Or are they, are most of the divorce lawyers older and there's not younger ones taking up the mantle? Have you had any observations in that regard?
Without any insult intended, I'm sure, Beth.
Yeah.
Yes, we older lawyers readily see
on
that.
the back nine.
Yeah.
Was that fair? Was it unfair?
No, it's very fair. No, especially if I par the holes on the back nine. I would.
Give him a birdie.
I celebrate that. That metaphor is terrific. Exactly what I see. I do not see young lawyers coming up. I would say because it is a very difficult practice. It's a practice where it's a 24/7. I mean, Brett, I'm sure you have that. I'm sure you have that too, given the nature of your practice. People need to find you and deal with you because something significant may have happened in an off hour. So yes, the clients will delight in the fact that you're responsive in the off hours. It's a regular occurrence in a matrimonial practice. I also say that being a litigator, COVID knocked our socks off because court appearances came to an end and virtual appearances then took over, and virtual appearances still remain the majority of the method of our court appearances. Judges like it. And so courthouse visits where you'd see who was hanging around, what the cases were, who the lawyers were, who the players were involved. I don't see that a lot. But to the extent that I do have an opportunity to come to know these things, I don't see a lot of young lawyers. And I think it's just the way of the world. It's tough, and they'd rather not devote themselves to this practice. If, however, they have an inkling to do so, there's business out there to be had because we, baby boomers in our early 70s, are joining the retirement rolls. So yeah, help yourself.
Have at it.
Anybody who wishes to buy me a large lunch to discuss the possibility of a divorce practice, I'm always hungry.
There you go. That's the best way to get to know your lawyer better. Take him to lunch, take him to breakfast, take him to dinner, take him somewhere.
That's right.
Well, Lew, thank you very much for your time. We really appreciate it. We don't want to triple bill everybody for our time here anymore. But from a marketing perspective, Beth,
please like, share, and subscribe. We would appreciate it. Thank you.
Thank you.
Thank you. My pleasure.